Welcome to Resolutions, the official podcast of the American Bar Association section of dispute resolution. Every episode is a journey into the heart of conflict resolution, guided by our diverse community of experts. We're here to explore innovative strategies, share wisdom from the field, and inspire excellence in resolving disputes. Whether you're a dispute resolution professional, a curious learner, or someone passionate about fostering understanding and peace, you're in the right place. Let's dive into today's conversation and discover how we can transform conflict into opportunity together.
Okay, welcome to Resolutions. I'm your host, Gothelf. This week I'm sitting with Peter Silverman and Tracey Frisch to discuss early dispute resolution and the power of risk-adjusted value decision trees. Peter Silverman is a partner at Shoemaker, Loop & Kendrick, an arbitrator on the AAA's large complex commercial panel, and a mediator on the AAA's mediation panel. Peter founded and chairs the EDR Institute and drafted their protocols for early dispute resolution. Tracey serves as Division Vice President of Mediation at the American Arbitration Association, leading its mediation business and advancing its strategic initiatives. She previously served as AAA's Associate General Counsel. Tracey has taught arbitration and mediation at Pace University School of Law, as well as the Cardozo School of Law, and has mediated through federal and state panels, as well as New York Community Mediation Centers. An accomplished author, she has written and presented extensively on topics in alternative dispute resolution. In addition to Tracey's role as Division Vice President of Mediation, Tracey serves as the Executive Director of the AAA ICDR Foundation. Welcome, Peter and Tracey.
Thank you. Nice to be here.
All right. Well, I'm glad to have you too. So, Peter, we'll start with you. Broadly speaking, what is early dispute resolution and how does it differ from other forms of dispute resolution like traditional mediation?
So traditional mediation, the way it's practiced now, is generally people will book a mediator a month or two out. They send a mediation statement a couple weeks out, and then they show up that morning and they begin going back and forth. And usually real bargaining begins about 3 o'clock in the afternoon. And it's generally pressure bargaining as you get closer into the evening. There's a lot of gamesmanship in the negotiation process, and the bargaining is generally positional. I'll go up 10 if you go down 10 type of bargaining. EDR's very different. So first, it starts right after the neutral is booked. So the neutral will say, very good, I'd like to start tomorrow. And the neutral gets into the process. It's virtual, and you go through 4 steps, which we'll talk about. You set a backup mediation date that might be 4 or 6 weeks out, or even shorter, 2 weeks out. But the goal is to try and resolve the dispute before even the backup mediation date. And instead of gamesmanship bargaining, it's principled bargaining. And the goal is parties should be able to have the self-determination to make truly informed judgments.
Now, a criticism of early dispute resolution is without some level of discovery completed, most attempts at early dispute resolution will fail. I'm going to ask, is this an accurate statement first? And say, I got this idea to ask this question from, in my experience, obviously as a case manager, sometimes in some of our largest cases here in California, we have a rule in commercial arbitration that if the claim is over a certain threshold amount, the parties should attempt to make a good faith attempt at mediation prior to the evidentiary hearing to move the case along and spare them the expense of the evidentiary hearing and hopefully walk away with a resolution everybody's happy with. But I've got to say, oftentimes both parties or one party unilaterally opts out of that requirement. And the main criticism I hear is they say, we don't know enough about our case to actually do an early mediation. What would you say to that?
That is an accurate statement. Yes.
In your process basically entails some discovery. So
Yeah. So what the principle is that we've come to is that you don't need discovery. That if you have good attorneys on both sides, they know exactly what they need to see to be able to make an informed valuation of the case. It's generally maybe something about damages, might be half a dozen documents, might be some kind of information, but it's the sort of thing you can make a limited request and the parties can exchange it, usually in just a couple days. So you get through that, the parties have sufficient information to value their case, and then we can move on. That it also helps deal with the emotions, the mistrust, and the biases that come in at the start of a case, because the implicit process is that parties start cooperating.
Right.
Somebody says, "Hey, I need to see this." The other side said, "Yeah, I understand." And you produce it. And both sides realize the other side's being reasonable and they want to see what is reasonable to ask for. So that's how we deal with that.
You founded the EDR Institute and drafted the protocols for early dispute resolution. Could you briefly discuss what the EDR Institute does and how you came up with those protocols?
Okay, so I started doing this about 20 years ago because I thought there was tremendous waste in discovery. Mediation is usually done before trial. So you've spent tens or maybe hundreds of thousands of dollars on discovery. And I always felt that there should be a way to address these issues initially. So the issues were, how do you get parties the right kind of information? How do you work through initial biases, emotions, and mistrust? And then how do you change the situation from positional bargaining to a bargaining based on a real risk analysis where the parties can have a principled negotiation? Through addressing those problems, I slowly came up with the protocols, and we finally formed the Institute in 2019, published protocols. The Institute provides training to neutrals. We've trained about 200 neutrals in the process. Lawyers, we've got a couple pilot projects with judges, and we're now working with the AAA to help qualify neutrals for the AAA specialty panel. And it will
Excellent.
be coming out in 2026.
So we briefly discussed about the discovery issues. Could you briefly take us through the full four-step EDR process you've
Yeah.
developed?
So the first step is simplification. Parties come in, they've listed 12 causes of action, and the defense has 17 affirmative defenses, and most of it's nonsense. And so you try to boil down the case to one issue, maybe two issues, and generally both sides know exactly what those issues are. And once you've simplified the case, that limits sufficient information because you don't need information on everything. And then, so that's the second step is exchanging that information. We've also got a process if you need experts, how to do that on an expedited basis. The third process is risk analysis. So you get parties to focus objectively on the risks of their cases. And so you can begin bargaining based on that. And the neutral has a basis for talking to parties and clients objectively about risk. And then the fourth stage is you work through what we call principled negotiation, negotiating on the merits rather than positional, try and get to resolution. If we don't get to resolution by the time of the mediation, you can have a regular mediation session. And if it still doesn't resolve, we'll work with parties to develop an expedited and economical binding decision process, usually through arbitration, so they can get to a decision.
All right, so how does probability logic and the use of decision trees fit into the process? And is this different than traditional mediation bracketing? And just very quickly, you might want to just describe to the audience what traditional mediation bracketing is.
So I'm a skeptic on traditional mediation bracketing. What usually happens is somebody starts, we'll pay 100, and somebody else demands 1 million. For about 6 hours, they get to the point where somebody's offering 100 and the other side's demanding 900. And then somebody will say, well, I'll go up to paying 250 if you come down to negotiating to offering 600 or offering 400, whatever. And that becomes the bracket. The other side responds, well, I'll go down to this number if you come up to that number. And the idea is that you try and get it to a realistic way. It generally doesn't work because it's gamesmanship. It's just silliness. And what you really want to do is talk realistically about what's a realistic range for a case. And the best way to do that is you think about, well, what's your likelihood of succeeding? And then pressure testing that. Is that really lit? Maybe it's a little less. And then what are your likely outcomes? What's the percentage likelihood you're going to get that? How much are you going to spend between now and then? And you can take that and put that into a formula called an expected value formula that looks at all the likely outcomes and discounts them by the likelihood of their occurring. You add in the costs and you get a rough value in the case, which is roughly where the case might end up if you tried it 10 times. But it gives each party a realistic idea based on what's their reasonable best case here. And that creates a natural bracket, not a game playing bracket, but both sides come in because they realize no case is 100%, and they get a feel for what's a reasonable way to assess that risk. So that becomes the bracket. And then you can negotiate based on objective factors. And the neutral can talk to people about, do you really think damages would be this? What does that do to the number, et cetera?
Yeah, I've been in a number of mediations where I've seen these tit for tat little offers through the mediation bracketing process, and you're right, you can waste an entire day doing that.
Right.
And I used to always say, if somebody doesn't settle it during the mediation, at least you'll always know more about your case coming out of it than you did going into it. But sometimes
Yeah.
that's not necessarily true if you don't move the needle at all during the mediation process.
Yeah. So here, Aaron, you really do because the parties have agreed on what's really at issue. They've exchanged the key documents. They've really gotten into the merits of the case from the risk analysis process. So they've learned a tremendous amount by the time they're done with this, much more than traditional mediation.
What types of disputes are most likely to be resolved using your EDR process?
Right now, we think it's applicable to every every type of case other than domestic. And domestic uses a process called collaborative law, which is very
And
effective.
just really quickly, when you say domestic, you mean like family law?
Divorce,
Yeah,
family
divorce.
law.
Yeah.
But other than that, we apply it to every type of case, no matter how simple or complex, the process works well, and it's flexible. So a neutral learns how to use it. So for a simple case, there's not much to do. You can try and solve a simple case in a couple hours. Complex case might take more, but it is applicable across the board.
Now, I know you said you mentioned earlier that you haven't necessarily done a study to see which industries are the biggest users of EDR in general, but there are certain industries that are big fans of mediation. So I use the example just about any type of personal injury or medical malpractice case where there's an insurance carrier involved and an adjuster and all that. It's going to go through some mediation at some point, and usually resolved in mediation well before trial. Do you know any industries that are big users of EDR already or that you suspect?
So right now it's been supply driven. We have trained, as I told you, a couple hundred neutrals. So they applied in their practices to the types of cases they get. And because we've trained 200 neutrals, it's a broad variety of cases. With personal injury, it works very well because insurance carriers have to reserve for a case. And what they reserve is a probabilistic number based on their own data. So they're very used to that. For plaintiffs, it works great because plaintiffs usually work on contingency fees. If they can resolve it earlier rather than later, it works very well. So it's a perfect fit for that. The only challenge is it takes time to get medical records.
Right.
So whereas we would generally say, let's start tomorrow. In a personal injury case where you need meds, you got to wait till the medical records come. But once it come, then the process can kick in right away.
Now, one of the reasons with bracketing, especially with highly contentious cases, bracketing tends to fail. Are highly contentious cases, where both sides have already kind of drawn lines in the sand, right for this process, or do both sides really have to be in a resolution mindset for it to be successful?
They have to be in a resolution mindset. So this process, what we teach is it's not right for every case. And so my engagement letter, I require both parties to make the representation that they're coming in good faith and that they're going to try and resolve the dispute on the merits early and economically. If they both do that, the process is very effective. If they don't, it just doesn't work. And because it does require a lot of cooperation and trust, and parties who don't come with that mindset won't be able to go through it.
Now, we briefly discussed this before, but what about cases where one or more parties is pro se, and have you seen the same level of resolution success with unrepresented parties? Now, before you answer that question,
Yeah.
I guess I'd preference it this way. There's never been more free information out there, especially with AI and ChatGPT and things like that, at the hands of pro se individuals, right? And that's both good and it's bad because some of that information is very useful for their case. Some of that information is just flat out wrong, right? In your sense, how would this work with a pro se individual?
So right now, it's very challenging with pro se because the steps we go through require some knowledge of the law and how cases work out, right? So simplifying the case, what do you really need to see? How do you account for the risks, percentage likelihood? Very difficult for pro se. And the neutral is very involved with this. So the neutral with the pro se plaintiff is going to be uneasy that the neutral's kind of telling giving pro se legal advice. What the AAA is doing with AI is very exciting and I think holds tremendous potential for pro se and for broadening justice. That if you could get a trained AI that a pro se plaintiff could use to give the pro se plaintiff or pro se party an accurate assessment of the risks in the case, the pro se party generally wants a fair resolution. They just have no idea what a fair resolution might be because they don't deal with this. But if an AI evaluative tool could say to them, hey, this is where I think you're weak, this is not, this is how you might want to discount it, I think it could be very effective and a real advance in justice because everybody wants a fair resolution of their case.
So, early neutral evaluations are probably the most well-known form of early dispute resolution. How does this process differ from a traditional early neutral evaluation session?
So, traditional E&E, the parties send briefs to the early neutral evaluator and exhibits. The early neutral evaluator looks at it some analytically and will come back, and people do E&E reports differently, but they might say, I think the plaintiff has a stronger case because of X, Y, and Z, but I think it will really turn on the credibility of the testimony of Mr. Jones. And I could see that going both ways. And the E&E will go through that to inform the parties. Here, we ask the parties to do that work. So I'll say to a party, what do you think is the likelihood you'd win on your breach case? And they might say 80%. And at some point, I might say, well, what about this? What about that? Do you think there's really a range? And so, in that sense, a neutral's working in a way like the early neutral evaluator without giving where the neutral comes out on it, but forcing the parties to think through that. And with very good lawyers, ultimately lawyers want to give their client the real information so the client can make the decision like we all make decisions in our everyday life. So it's a much different process than E&E, but a lot of the variables are the same.
Yeah, I like to point out that, we have a early neutral evaluation panel here at AAA, and I always felt it was one of the most underutilized part of our panels because E&Es can be incredibly helpful, especially if you have a client that's maybe a little bit more stubborn or has an unrealistic view of their case, to have kind of an expert come in there and sit down and say, listen, I've seen 500 of the same cases during my legal career. I can tell you exactly how a jury is going to see this. And if you want to spend the time and the money going to trial to have the exact same result I'm going to tell you is going to happen right now, it probably doesn't make a whole lot of sense.
So
Okay,
it's
well,
terrific. Just quickly, it's terrific. Parties are often reluctant. E&E can cost, I don't know what people are charging the panel, but my guess is $15,000, $20,000. If the AAA is successful in continuing to develop their AI evaluative tools, then it would become almost no cost at all. The parties could get, just a realistic neutral look. That would be an incredible leap in dispute resolution.
yeah, and we've seen tools come out over the last couple of years, with like Lexis and Westlaw, et cetera, that kind of allow parties to predict the value of their case based on previous jury verdicts that you can always search. And occasionally, even in private mediations, the parties decide to release the results of what cases settled at. In California, for example, we have a publication called the Daily Journal, which is a statewide legal newspaper. And there is a settlement section towards the back of it where sometimes the parties decide to kind of announce to the world what a case settled at.
Hmm.
All right. If a neutral is interested in EDR training, is that something the EDR Institute offers, and how can folks get in contact with you?
We do 2-day live trainings. We don't have any scheduled now, but we've got a streaming course that will go online. It'll be about 6.5 hours and should be available at the beginning of 2026. And if you go to our website, edrinstitute.org, there's a space you can sign up if you're interested in the 2-day training.
Fantastic. Okay, on to Tracey. Tracey, how is this new panel the AAA is developing different from other early dispute resolution services that the AAA currently offers?
Thanks, Aaron, and thanks for having us with you on the podcast. So the AAA's traditional mediation and early neutral evaluation services are well established. I agree with you. I think our E&E panel is underutilized, and they're valuable tools in the ADR landscape. The EDR mediation panel focuses on a structured, multi-step process designed specifically to resolve disputes early, as Peter said, typically within 30 to 60 days, rather than functioning as a one-day event. And this process integrates risk analysis, principled negotiation as core elements, like Peter did a nice job explaining. The new panel is going to consist of mediators formally trained and qualified by the EDR Institute through their protocols and training for uniform proficiency in the steps and analytic tools that distinguish EDR from other early resolution services.
And considering that, we already have various early dispute resolution services, why is AAA starting a specialty panel specifically for these qualified EDR neutrals?
So there's a growing demand among clients and counsel for services that resolve disputes earlier, more economically, and with greater predictability than traditional litigation timeline or, I think, single session models. So EDR represents a best practice approach that combines structured information exchange, case simplification, risk-adjusted analysis, all of which require this specialized training to execute effectively. And by offering a dedicated panel, the AAA can elevate the consistency and quality, ensuring that parties have access to neutrals highly skilled in the EDR process. I've been very impressed. I've been involved in the mediation field for a very long time. And when Peter took me through what this EDR process entails, I was very impressed about the steps that the neutral goes through with the parties and sort of how clearly defined they are and how it brings it through a process where, like Peter said, even if it's not a resolution, which generally it is, you're getting a much clearer idea of what's really at stake in the dispute, what your risk is, and what a likelihood of success might be in terms of a negotiated outcome.
All right, because I know this is going to be a question I'm going to get from a lot of the panelists that listen to this podcast. How does one join the panel, and do you already have to be on the existing AAA mediation panel?
So candidates for the EDR panel are going to need to demonstrate both a strong mediation background and specific EDR training and proficiency. aligned with the EDR protocols and trained through the EDR Institute. And while being on the AAA mediation panel reflects foundational mediation expertise, EDR competency goes beyond that traditional mediation training. So completion of the EDR specific instruction, which we are partnering with the EDR Institute to offer, will be critical. For the initial cohort, we worked with Peter and other stakeholders, Ann Jordan, Michael Hawash, and Felicia Haas-Harris from the EDR Institute to identify mediators who are both qualified to be on the AAA's mediation panel and who have the training and expertise through the EDR Institute. So there were folks who were recommended by Peter and others from the EDR Institute who we're going to be inviting to join the AAA's mediation panel as part of this.
And I certainly recognize some of the names that you just mentioned as also being part of the ABA dispute resolution section's subsection for early dispute resolution, which is another great place to get information. What types of neutrals make good EDR practitioners? And just this is my perception that most early neutral evaluators, for example, come from an evaluative approach. And can neutrals that use a facilitative approach be just as successful at resolving disputes through EDR?
I think absolutely. I actually see this as a very facilitative process. I think effective EDR practitioners combine the strong analytical skills with very excellent facilitative instincts. In order to reduce a dispute into the core claims, that's facilitative work. They help parties assess risk realistically while also guiding this principled negotiation. I think unlike classic evaluative mediation, which primarily focuses on sort of the neutral's assessment of the case, how they think it might turn out, EDR neutrals blend risk analysis with structured negotiation and information exchange. So it is a much more facilitative process. I think facilitative neutrals can be highly successful in EDR when they're trained in the protocols because facilitation is crucial to building the trust, clarifying the interests, and guiding parties through principled decision making. The ideal EDR neutral, as I see it, is flexible, comfortable with evaluative tools like risk adjustment, but also skilled in engaging parties collaboratively towards an early resolution.
These days, everyone's talking about using technology to resolve disputes. How is AAA using risk-adjusted value software to help mediators resolve disputes? And is this actually considered AI-assisted dispute resolution?
So the EDR protocols specifically incorporate risk-adjusted value analysis, which often uses decision tree techniques and analytical tools and software to help parties understand the likely outcome, probabilities, and settlement ranges. And while the use of analytical software supports clear, data-informed conversations early in the process, it's not the same as a generative AI tool who's doing some reasoning, doing some decision making. Rather, it's a tool to help neutrals and parties inform their decision making more precisely. So I'd say it's an assistant rather than a doer. And at the AAA, obviously, innovation includes both human-centered analytics and emerging technologies, including the responsible human-in-the-loop AI that we've created through the AI arbitrator and other tools where we've been incorporating AI. And the use of technology in EDR, I think, enhances the efficiency and understanding without replacing the neutral's judgment. Now, could I see advances of incorporating AI into the EDR process? Absolutely. But traditionally, through what Peter's teaching through the EDR Institute, is the use of software and creating these decision trees. But the input is done by the parties and the neutral together.
Yeah, and I briefly talked about this in my podcast episode with Bridget on the AI arbitrator, if that might be made available to parties to kind of see how the AI would make a decision. And it wouldn't necessarily be binding, but would give them a lot of motivation to settle kind of once they saw kind of how the chips would fall. One way, especially with consumer disputes, whenever there's a dispute, most companies tend to have a process on processing those disputes. And before an arbitration or a mediation takes place or any type of litigation, certainly there's usually some sort of internal process where the company tries to make right whatever it is that was made wrong. And if they can't resolve it through that, it goes to a more formal process. Is AAA working with companies to develop internal EDR processes for in-house counsel to resolve disputes before outside counsel needs to be retained, and it kind of goes down that road?
Yeah, I think, like you said, many organizations are proactively embracing early resolution strategies that integrate dispute management before litigation is going to escalate, right? That's the most cost-effective way to go about things. I think AAA's leadership in ADR and innovation and training positions it well to support internal dispute systems design, including EDR-infused processes that allow in-house counsel to manage risk, cost, and conflict earlier and more strategically. While specific partnerships might vary by company, the AAA, we do offer education, training, support, and to enhance in-house capacities and reduce reliance on expensive external litigation. And I absolutely expect that the EDR panel in this process will be popular for in-house counsel.
All right, now, this next question is just the cynic in me, and I don't mean this across the entire legal industry as a whole, but in a world where law firms are still using the billable hour, how do you convince attorneys that resolving disputes early and billing their clients less hours is actually good for their bottom line?
Right. I mean, part of what the lawyer's job is to make their client happy, right? And what client isn't happy when you're not doing all the no stone unturned discovery, spending all this money on motion practice, but really looking at something from a strategic standpoint. I think that in-house counsel is really leading the way in directing outside counsel in perhaps getting rid of the billable hour. I think there's a lot more flat rate going on. I think in-house counsel is pushing outside counsel to utilize AI to bring more efficiency to their work. I think a lot of this is going on at the same time. And I think clients today are increasingly sensitive to legal spend and value outcomes. By resolving disputes early, attorneys can build stronger client relationships, attract new business, and align their practices with the market expectations of today. I think EDR encourages strategic deployment of counsel's expertise, focused preparation, risk analysis, principled negotiation. All of this is going to deliver a higher value result while managing costs more effectively, and that's going to make any client happy.
Perfect. How can folks reach you to learn more about these services? And do we have a special landing page set up at adr.org, or is that in the process?
It's in the works. So interested listeners can visit adr.org/mediation, where the AAA highlights its mediation services, training opportunities, and panels. And we'll be launching a special landing page for the EDR panel specifically. We'll also be adding EDR as a practice area on our mediator search tool, which is mediatorsearch.adrapps.org. You can also get there through our homepage of adr.org. And we'll be highlighting the mediators who are part of the EDR panel on that search tool as well. And for general questions, you can reach out to mediation services at adr.org or to reach out to me specifically. I'm FrischT@adr.org. And also keep an eye out on the AAA's Mediation Magazine, which is mediationmagazine.adr.org. Peter wrote an excellent article there on EDR, much of what we talked about today. And I know he plans to continue publishing on the topic as we move forward.
Great. And then is there anything else either of you would like to share?
I could comment on two things that you went over with Tracey. So what do I think this is going to look like in 5 years? AAA is developing this incredible array of tools, and I would see AAA working with all companies who use this process, and I think parties will really like it, to give them a curriculum that's an integrated dispute resolution process internally. So they can even train their transactional lawyers and their dispute lawyers on how to think about simplifying risk analysis so they can negotiate in a informed manner, and that they can know if they can't resolve it that way, then they can go into early dispute resolution. And they know that if they do it well, they can get it done in 10 to 14 days to see if it resolves. And if not, they can schedule an expedited economical arbitration. So I would see AAA giving companies coming to AAA for the entire package in consulting. And I'd see the norm for anybody who wants to file arbitration to say, let's give this 14, when you file, you're going to have 28 days probably before your arbitrator is selected. Let's try and do this EDR process. We might resolve it. If we don't resolve it, we've gone a long way toward understanding the case, and then we can move the arbitration along quickly and economically. So that's where I see it going in 5 years. And what AAA's done is really, it's amazing. I really think it's going to transform dispute resolution.
Excellent. And Tracey, anything to add to that?
I'd say the AAA is all about innovation. We say we're a 100-year-old startup, and I really see this as an innovation in the mediation space. It's something new. I think it's something very principled. It makes a lot of sense when you look at it. You're like, oh yeah, that really clicks. So I'm excited about it. I'm excited to roll out the panel and to teach folks about what this is, so clients can get to know what this process is all about.
Well, thank you both for spending some time with me this afternoon. And here's to EDR hopefully resolving some disputes in 2026. Bye.
Thank you.
Thank you.
Thank you for joining us on Resolutions. Today's episode has illuminated the powerful impact of effective dispute resolution and showcased the incredible individuals who dedicate themselves to this important work. Our mission is to explore the diverse world of dispute resolution, and we hope we've inspired you to engage with conflict and collaboration in new ways. If you're not yet a member of the ABA section of dispute resolution, we invite you to join our community of professionals making a difference. Your involvement can help us build a more harmonious society together. And if you found value in our conversations, please consider leaving us a review and a 5-star rating wherever you listen to podcasts. Your feedback helps us reach more people and continue our journey towards excellence in dispute resolution. Until next time, keep solving problems, building bridges, and creating positive changes in your communities.